Okay, so with that housekeeping stuff out of the way, let me just get on to the important bit, which is welcoming to speak to us today Professor Cathy Sherry of Macquarie University in Sydney, Australia. Cathy is, I think, the world's leading expert on the Australia strata title regime and certainly has written and published extensively on this topic during her academic career. Some people on the call may or may not know about the apartment law system that they have in Australia, but one of the things that Cathy looks at in her work is the body corporate at the heart of the strata title regime in Australia, which is a little bit like the owners' associations that we are thinking of introducing in Scotland or looking at introducing in Scotland. One of the things that Cathy has looked at in her research is the circumstances in which the body corporate can be a good thing for the strata community, and the circumstances in which sometimes the body corporate perhaps has too much power and can go too far. So she's looking at both sides of the coin, and that is something I think that we can learn a lot from when we are trying to figure out what our owners' associations should look like and how much power we might want them to have or not have in certain areas of the lives of flat owners in future. So without any further ado, I'll hand you over to Cathy and she can take it from here.
Thank you very much, Frankie. Apologies to everyone for the lateness. It was my fault. The technical problems were at my end here, so I'm very sorry about that. I will say just at the very beginning, I talk very quickly. I'm aware of this. So if I'm saying anything too quickly, please feel free to turn your mic on and yell at me to slow down. I won't be offended at all. I'm assuming, given the fact that we've inflicted decades of home and away and neighbours on you, that my accent is not a problem for you. But if you don't watch those edifying programs, it might be. So do let me know if I speak too quickly and you're having trouble understanding my accent. Okay, so what I was going to talk to you today about is about strata title and the advantages and the disadvantages of the system. Because I'm an academic, academics are kind of paid to be negative, so we tend to see the negative aspects of the law that we're looking at. We're always looking for the problems. So although I will say some critical things about strata title, I think that on balance it's a pretty good system. I think there are some inherent problems that are unavoidable, but I think it's a relatively good system. I've had a look at the Scottish Law Commission's reference and what the things that you're looking at with your law. So I'll try and tailor this presentation a little bit to match the kind of concerns that you're looking at in your law reform. Just by way of introduction, just a quick bit of sort of setting the landscape, so to speak, of Australian property law and the way in which Australian strata title operates. Obviously, Australia is a very old nation, though Australia was invaded by the British in 1788. And Australia was largely settled by working class English, Irish and Scottish people. So that profoundly affects our property law. We have no landed aristocracy and we have no long-term leasehold. So that's a significant thing in Australia. We have long-term leasehold in rural areas, but not in cities where most Australians live. The Australian property landscape is that by 1970, 70% of Australians owned their own home, which is the freehold fee simple. They were not tenants. About 20% of people live in the private rental market, and only about 10% of the Australian population lives in social or public housing. It's actually very low relative to the United Kingdom. But the significance of that kind of makeup of the Australian housing market is when we started to develop apartments en masse, and that was relatively late in Australia because, as obviously most people are aware, Australia has a relatively small population. It's currently only 24 million people, and we have an awful lot of land. So Australia is the size of the United States. Americans often don't believe that, but it's true, we are. So we have a lot of space, which meant that we didn't actually have to live in apartments initially, because we had a lot of space. Also, just the sort of coincidence of history that the settlement of Australia kind of coincided with the Industrial Revolution. So while the initial development of houses in Australia had to be, as they were in Europe for centuries, within walking distance of city centres, very quickly railways were developed. And so Australia has an awful lot of suburban development, which meant we could spread out and people lived in freestanding housing. But when that kind of urban spread started to become a little bit problematic and Australian cities sort of grew and grew, and we started to think about how we might consolidate cities, one of the essential things that Australians had to look at was how do we actually have freehold ownership of apartments, because that's what Australians are used to. It's very hard to convince Australians to buy long-term leasehold. They don't tend to be interested in it. They're not convinced it's a good form of property ownership. So one of the things we had to look at was, how can you have ownership of apartments, but people own a freehold fee simple? That is, they are not tenants. They are simply the owners of their interest in land. And the biggest problem that we had was overcoming the prohibition on positive obligations on freehold land. And I'll try not to be too technical about this. And it's a rule of ordinary property law, and it's very interesting for me to be talking to people in Scotland, because when I write, I tend to trot out the sort of standard line that there are only 3 jurisdictions in the world that allow positive obligations on freehold land, and they are the United States, Israel, and Scotland, because I know that in Scotland you don't actually have the limitation that exists in English and Australian law and in the law of many jurisdictions, common law jurisdictions around the world. And that is the restriction that says if you are going to sell a freehold fee simple, you cannot impose a positive obligation on it. And what I mean by that is, if you're the owner of land and you're selling the freehold, you can't impose an obligation on that property title that the next owner and every subsequent owner after that do certain things. And the most obvious positive obligation people want to impose on land is an obligation to pay money. Now, you clearly can in relation to a lease. So if you're creating a lease, you can make people do all sorts of things. You can make them repair the land. You can make them pay rent, most obviously. But if you're selling a freehold fee simple, you can't do that. There's a narrow exception with restrictive covenants, but restrictive covenants of their nature have to be restrictive. You can stop people doing things, so you can stop them building in certain materials, you can stop them subdividing land, but you can't make them do stuff. And this is a fundamental impediment in most jurisdictions to creating freehold titles to apartment buildings, because if you want to build an apartment building and you want to sell people a freehold interest, that is a fee simple ownership of an apartment, you are sooner or later going to run into the problem of having to maintain that building. So all buildings need to be maintained, and you're going to have to impose monetary obligations on people to pay for the upkeep of that building. But if you are using orthodox property law in most jurisdictions, you can't actually do that. So sorry about that little bit of technical property law. I'm now going to move into stuff that is hopefully a little bit more comprehensible. And that is the Australian strata title system. The primary reason why we have legislation in Australia is to overcome this inability to sell freehold fee simple titles and make people pay for the upkeep of the building. So we solve that problem by enacting special legislation, strata title legislation. It exists in many jurisdictions. It's sometimes called unit title, sectional title. In America, North America and Canada and America, it's called condominiums. It's all the same thing. And the way it works is you register a plan of subdivision. So you subdivide land and a building into individually owned lots and common property. And those lots might be an apartment, or they can be in master planned estates. It might be a vacant block of land. It could be a house, it could be a townhouse, but that's individually owned by someone and they own the freehold to it. And they also become a collective owner of common property. They're tenants in common, which is a technical legal term. It just means that you collectively own it. And it means that everybody has the right to use the common property, which might be the lifts and the stairwells in an apartment building, the parking spaces. But in a big master planned estate, it can be the roads, it can be parks, it can be tennis courts, swimming pools, black water, grey water treatment plants. It might be trigeneration plants. It might be solar panels. It might be embedded networks for green electricity. So that's collectively owned common property. When you buy an apartment in Australia, you automatically become a member of a governing body corporate. And I know that's something that Scotland's looking at now. Interestingly, in America, when they first started to do these developments, developers were not required to create a governing body corporate, and they eventually discovered they ran into real problems with the fact that they were collecting money, but there was no one to hold that money or give it to, and there was no one to run the community. So America retrospectively created legislation that said when you create this kind of multi-owned developments, you must create a governing body corporate. Australia, it's always been the case from the inception of our legislation. The moment you register a plan of subdivision, subdividing a building or land, you automatically create a governing body corporate. corporate that is made up of all of the owners, not the tenants. So in Australia, about 50% of apartments are actually rented on short-term residential leases. So they'll usually be 6 months or a year. And the owner of those apartments will just be individual people. So most people, we don't have large institutional landlords. Most landlords in Australia maybe own 1 or 2 properties, but many landlords who do own properties, investment properties, own them in apartment buildings. So in apartment buildings, about 50% of the residents are tenants, but they are not members of the body corporate. So it's this kind of strange back to a time when voting rights were dependent on land ownership. So Australia does have a bit of a problem with the fact that tenants, although they make up 50% of our apartment residents, actually have no say in the governance of the apartment building because they are not members of the body corporate. So the legislation creates that body corporate automatically. The legislation also imposes a statutory obligation on the owner's corporation to maintain and repair the common property. So that's a big difference to non-strata property. In a non-strata property, so, you know, your freestanding house, your ordinary terrace, you can let your house fall down around your ears if you so choose. In the long run, you'll either have to fix it because you need to in order to live in the property, or when you come to sell the property, you will, you know, wear those costs in a reduced purchase price for the property. But you are actually free to allow your property to fall down around your ears if it's not strata title until you get to the point that it's a danger and you'll get a demolition order from a local council. But, you know, it takes a lot to get a demolition order from a local council. But strata title is quite different to ordinary property ownership. There is a statutory obligation to maintain and repair common property. Everybody has to do it. And the owner's corporation or body corporate, sorry, I'll use those 2 terms interchangeably, it just means the body made up of all owners, has to every single year estimate how much it will cost to run the scheme and to do maintenance and repairs, and they have to levy the owners, that is extract money from them, that's what levying is, extract money from them to pay for maintenance and repair. And there are 2 funds they have to pay that money into. There's an administrative fund, which is for day-to-day expenses, so the expenses of convening meetings, you know, maybe, you know, paying for electricity, that kind of stuff. And then there's a capital works fund, which is meant to be for maintenance, more obviously capital maintenance of the building. Levies are done on a unit entitlement, and a unit entitlement is just a random number that's allocated to each apartment when the development is created. And when I say random, the proportion is not random, but the number is. So you could say you've got a 10-lot strata scheme, the total unit entitlement is 100. Some units have a unit entitlement of 5, some have a unit entitlement of 15, some of 20. It all adds up to 100. The actual number allocated to each unit is kind of meaningless, but the proportion is significant. So people pay levies in proportion to their unit entitlement. Unit entitlement, there's been some dispute in various Australian states about how to calculate that. It's done on the market value of the unimproved apartment. In your jurisdictions like the United States, it's done simply on the area of the apartment, so the square metre, or in America, square foot of the apartment. In Australia, it's done on market value. It hasn't caused a lot of disputes other than in states like Queensland where they can't seem to agree on it. So because it's done on market value, the penthouse on the top floor will have a greater unit entitlement, so we'll have to pay more levies. Some penthouse owners say, but I don't use the common property any more than anyone else. Why should I have to pay any more for that? That can sometimes cause disputes. That can be hard to work out. Most states in Australia haven't had too much dispute about that. But that's one of the key elements to strata title, is that everyone has a statutory obligation to contribute to the maintenance of the building. The second thing about strata title is it allows for the creation of bylaws, and these are, just to be very clear about this, these are not public laws. So I don't mean bylaws in the sense that you might have council bylaws in the United Kingdom. These are not rules created by public bodies. Bylaws are the rules that apply simply to an individual strata scheme. They're initially registered by developers. There are model bylaws in the legislation that developers can use, but they don't have to use them, and they can actually be altered by the owners' corporation after once people have bought apartments and are now members of the owners' corporation. They could only be altered by special majority vote, which is, people say it's 75%. It's not. It's actually a vote against. Not more than 1/4 of votes are cast against it, and it does actually make a difference. 75% versus not more than a quarter of people have voted against it. But it's a special majority. You need to change bylaws. So once they're in place, they can be quite hard to change. They were initially always thought of as just housekeeping matters. So, you know, where to put your bins, or you can't make noise, or Australians, this will probably horrify people in the United Kingdom, Australians were very big on banning pets in apartments because most Australians live in freestanding houses with big blocks of land. When a strata title was initially introduced, Australians had this kind of conviction it's cruel to keep a dog in an apartment. You shouldn't keep dogs in apartments. And so many Australian strata schemes banned pets outright. And that's caused an enormous amount of dispute in Australia. And it's only just started to change that people are now free to keep animals in apartments, so cats and dogs. But I'll talk maybe a bit more about pet bylaws later, because it's very instructive about the dangers of allowing people to regulate other people's homes. But and I don't think this is something that Scotland's looking at, what I understand from Frankie, but in most strata title systems, there is this power to write bylaws. In New South Wales, in most Australian states, it's a very broad power, and it means that you can have bylaws that regulate not just the use of common property, but individual lots. So it's a very important thing about most strata title systems, and this exists in the United States, it exists in Canada, New Zealand, in almost every jurisdiction that has this form of property ownership. The owner's corporation, it'll initially be the developer, but the subsequent owners has the power to write rules about the use of not just common property, but people's individual apartments. And this, as Frankie said, is what a lot of my research is about. It's basically a private legislative power. It's legislation that empowers private citizens to regulate their neighbours' homes. And one of the things that's happened in Australia is there's been very little awareness of the dangers of giving private citizens the power to regulate their neighbours' homes. One thing that I've looked at in my research is United States law, actually, sorry, before I go on to that, sorry, I will say one other thing. Just talking about once we got strata title legislation in Australia, initial developments in Australia tended to be quite small developments, like 3-story walk-ups, usually with 12 or maybe at the most 24 apartments. Obviously, as time has gone on and engineering developments have changed, we can now build 156 stories into the air because we no longer use load-bearing walls. Our apartment blocks have got bigger and bigger. So now we have a lot of high-rise towers. They often house, they can house 500 or more residents. They're really very, very big, complex developments. And we also have master planned estates. We don't have an enormous number of those. They're much, much more common in North America, where North America has entire suburbs that are basically a single owners corporation. So basically they're private suburbs. And if anyone has a taste for incredibly lowbrow American reality programs, you might have watched something like The Real Housewives of Orange County, those kind of American master planned estates. That's the legal title that we're talking about. All of those, the reason why the kids drive around in golf courses is because golf carts and things like that, and are often getting in trouble for doing the wrong thing in their golf carts, is because those kind of communities are entirely privately owned. The roads are privately owned, all the facilities are privately owned, all the houses look the same because they are very tightly regulated by bylaws that are created and enforced by the private community itself. These kinds of really large developments, and this is something that I think that all jurisdictions looking at introducing or reforming their apartment law need to be aware of, these kinds of very large developments tend to have a lot of businesses associated with them. So as soon as you start building very big developments that have facilities and need to be managed and have a lot of people living in them, you immediately create an opportunity for third-party businesses. So management businesses that are associated with this. In North America and also in Australia, in many jurisdictions, there have been real problems with management companies that are installed by developers that owners then have no control over. They buy into a development. They don't really understand what they're buying into. There are already very complex contracts in place in the developments that they've bought into, which I'll talk a bit more about in a moment. But the result is these developments are extremely complex. They're not just a 3-story walk-up that maybe has 24 homes in them. They are a 56-story building, or they are an entire suburb that has really complex facilities and a very, very complex management structure. I did mention the United States, and I will say something about the US. Australia and many parts of the world copy their development from America. So property development is a global phenomenon, and many property developers work all across the globe, and they want to build the same kind of developments, whatever jurisdiction they're in, and they will find a way to do it. And American development is very influential globally. And one of the interesting things about America is America has long had, it's very unusual in that in America it's always been possible, or since the 19th century, it's been possible to sell a freehold fee simple, so a fee simple interest in land with an obligation to pay money. But in the early 20th century, there was a significant American decision, actually in 1938, so sort of mid-20th century, there was a significant American decision called Neponset Property Association, Owners Association against Immigrant Industrial Savings Bank. You don't need to worry about the name of that case. The reason why I mention it's significant for Scotland, because this is the case where American courts decided it was okay to have a separate entity that was made up of all owners, that they had the power to collect money that was a monetary obligation that was imposed on all owners who bought properties in that development. And that separate organisation could collect that money, spend it as it collectively decided, but also could enforce rules in relation to the development. So they are very often very detailed architectural rules about how people can build, what they can do, how they can behave in a private development. And I think I'm right in saying that's what Scotland is looking at, the idea that it's a good idea if you can collect money from people to maintain a building, which is necessary because buildings eventually will fall down if they're not maintained. But if you are collecting that money, it would be a good idea to have a separate legal entity that can hold that money and spend it and make appropriate maintenance decisions. I think the thing that all jurisdictions have to be careful about is being aware of the powers of that association. And certainly in the United States and in Australia and in most jurisdictions, the powers of that association is not simply to collect money and spend it on maintenance. The powers of that association is to create and enforce rules in relation to the development. And I'll just give you a quick example of the dangers of allowing a private association to have those kind of powers. And it's the one I always give people that is shocking to people outside the United States. Most people in the US have some idea that these rules existed. But throughout the 20th century in the United States, it was standard to create residential subdivisions of the kind that we're talking about that had a private owners association and collected money for maintenance of the association. It was a standard to include rules in those developments that restricted land to the occupation of Caucasian people only. So what are referred to as racially restrictive covenants. So in Australia, we would have rules that would say something like you can't build in anything other than brick and tile, and that was to make sure the developments looked nice, you were using good building materials. In the United States, it was standard to have those kind of architectural restrictions, but also to have restrictions to say that a developer would create when they subdivided a suburb, they would impose on all of those parcels of land a restriction that said only Caucasian people may live on this land or buy this land. Now, obviously, that created a system of residential apartheid that the US still struggles with today. Obviously, deeply offensive, deeply wrong, but endured for most of the 20th century in America until they were finally declared unconstitutional. And so developments can no longer impose racially restrictive covenants, but they still create exclusionary covenants in a whole lot of ways. So these are rules that attach to freehold land. A classic example would be in America, they routinely have single family only covenants, rules that restrict occupation of apartments or houses in developments to single families, which is a very odd concept, I think, for people in other jurisdictions. In Australia, we have residential restrictions, that is, you can only use land for residential purposes, but we don't peer into people's houses and try to, micromanage the makeup of the family that lives in that house. In America, they do. So single family mean that only biologically. Sorry, I could just hear someone's asking me something.
Oh no, sorry, apologies.
Sorry, that's all right. So in America, it means that they actually look into the composition of the household to say that only a family, a legally married man and woman and their biological children may live in that development. It obviously has very discriminatory effects against a whole range of people, but in particular certain groups of communities in certain communities who are more likely to live with extended family, more likely to live with de facto partners, all of those things. So there are all sorts of ways in which these private rules can operate to discriminate against people and individual people and groups of people. And it's something that really needs to be borne in mind when you give private citizens the power to create rules that regulate other people's homes and large swathes of land. Australia has not had huge problems with these private rules, but I believe that is simply because Australians don't have a strong history of racial segregation. Don't get me wrong, Australia has a strong history of racism, like most countries, and we have a long history of appalling treatment of Indigenous people, but we don't have a history of racial segregation in residential housing. And also, I think that a lot of Australians simply don't realise the power that strata title gives them. So I'll give you two examples. The first is that it's always long been the case, it's always been the case in Australia that, for example, you can ban people smoking in apartment developments anywhere in the apartment development. You can ban people smoking inside their own kitchens, even if there is no smoke drift that affects anybody else in the building. Because in Australia, the way legislation was written, the power to write bylaws is just that you may write a bylaw as long as it relates to the use or enjoyment of a lot or common property. That's what the legislation says. The body corporate has the power to write a bylaw as long as it relates to the use or enjoyment of a lot or common property. And almost anything falls within that. So a bylaw banning people eating meat in their own apartment relates to the use or enjoyment of a lot. And incidentally, in India, that's used as a covert form of religious discrimination if you ban people eating meat. It bans Muslim families. But you could write a bylaw banning people smoking anywhere in a development, and that is a bylaw that relates to the use or enjoyment of a lot. As I mentioned before, Australian apartment buildings routinely banned people keeping pets, even if that pet had no effect on anyone else. So a cat that never leaves an apartment, I know that might sound strange, but in Australia it's actually standard for people to keep their cats locked up because they kill wildlife when they're let out. I know that's probably unusual in the United Kingdom, but many councils in Australia require you to keep your cats indoors at all times. So people could have cats in apartments that never left the apartment, but they'll still be banned. Or you might have an entirely silent dog who doesn't disturb anyone ever, but they would still be banned. And that's caused an enormous amount of dispute in Australia. We're gradually seeing a change of those rules. So part of my research has been arguing that you should never be able to write a bylaw in an apartment building that regulates anything that anyone does inside their own apartment that does not have a meaningful effect on somebody else. And you might think that that's a really obvious thing, but it was never written into the legislation, which is one of the risks of having property law that's created by legislation, that's created not by law reform commissions as yours is being created, but in Australia, the original strata title legislation was written by a consortium of a committee that was supervised, convened and paid by a consortium of property developers. So Australian strata title legislation has always been very influenced by the property development industry, which is a very real risk in this area. Just going forward for Scotland, it's always a risk because developers have the best paid lawyers, so they can often have quite a disproportionate say in this kind of reform. Look, because I want to leave time for questions, I'm going to just move on and flag a couple of other things that you might want to think about if you're introducing some kind of quasi strata title system or something that looks like this. Having a separate legal entity, an owners corporation that is a separate legal entity, can have its advantages and it can have its disadvantages. The disadvantage is that when you're talking about the initial creation of developments, that separate legal entity will be controlled by developers, and developers can cause that separate legal entity to enter into contracts. They then sell off the apartments and the people who purchase those apartments have to discharge the obligations of the separate legal entity. And the way what's happened all over the world is developers sell management rights. They install managers into large-scale developments. Contracts that are sometimes 25 years long allow the management company to charge the owner's corporation an enormous amount of money. People buy into developments, they don't really understand what that contract is, but once they become a member of the owner's corporation because they own an apartment, they are obliged to pay for that contract. And there have been enormous problems with management contracts all around the globe. Other problems just that strata title has, although you have a statutory obligation to pay for maintenance and upkeep of the building, no one checks that you actually do it. So it's not like corporate law where there's a corporate regulator that checks that companies are actually doing what they're meant to do, and they actually supervise them. In strata, although there is a statutory obligation to pay for the upkeep of the building and to have funds to pay for it, nobody checks that that is the case. Owner apathy is an enormous problem. So most people, when they buy a home, don't actually do so because they want to be part of a group that manages a building. They certainly don't necessarily want to take on the responsibility and obligation of managing a very complex high-rise building. So high-rise buildings are very complex. They have lots of plant and equipment in the basement. They cost an enormous amount of money to maintain. Most people, when they buy an apartment, they didn't do it because they wanted to be involved in that kind of activity. So owner apathy is an enormous problem in strata title. The businesses that are associated with large-scale developments can cause problems. So in Australia, owners' corporations can delegate the certain responsibilities for managing the building to strata managers. Some of those strata managers are very good, some of them are not very good at all. And there's a real problem with, I think, in the whole kind of strata world of people understanding that strata managers are simply engaged by the owners' corporation. The real power rests with owners, but because owners are often apathetic and don't understand what's going on, strata managers tend to exert a lot of power, more so than they probably should. And then finally, second last thing, mixed buildings, which I know Scotland is looking at, are very, very difficult. The experience in Australia, we have them. They are very complex. They are hard to run. The overriding thing I would say about mixed buildings is that the residential owners usually get done over and are exploited. So the system is set up by the developer and usually sometimes in conjunction with commercial owners, and all of the costs will be set before residential owners buy in. The residential owners buy in and things are often weighted against them. And it's also very difficult when people have different motivations for using property. So on one hand, it's someone's home, on the other hand, it's somebody's commercial space. You know, it's kind of inevitable that you're going to get clashes. And then finally, I'll just finish on this point just to leave time for questions. I know that you are looking at the question of termination of strata schemes. Termination of schemes, what happens when you want to knock down a building? New South Wales has recently changed its law in this regard. It used to be the case to knock down a building and terminate a strata scheme, you had to get 100% of owners to agree. That's recently changed now, so you only need 75%. That change was really pushed through by developers because they were very frustrated about the fact that they would sometimes buy 6 out of 8 apartments or, 32 out of 40 apartments, and a small number of people just held out and refused to sell. Developers found that very frustrating. They managed to push through the change in legislation on the ostensible grounds that there are some schemes that just need to be knocked down. Asking people to fix them is like moving the deck chairs on the Titanic. They just need to be, demolished, or an argument that there are many schemes on quite big blocks of land which could be built at much higher density. Both of those are valid arguments in favour of termination by less than unanimous agreement, but neither of them were actually put in the legislation. So, of course, what's happened is developers are aiming to terminate schemes simply where they will make the most profit. And in a city like Sydney, that means one thing: water views. So either they're on the harbour or they're on beaches. Developers are pushing people out of buildings that are their homes, sometimes elderly people who don't want to sell because they don't care how much they're paid, they just don't want to move, but they actually have no choice. Their apartments can be compulsorily acquired by a developer or by their neighbours, just if it would be financially advantageous to do so. So that's an area that I think is quite problematic in Australia. I'm going to finish now, sorry, to let people have a chance to ask questions.
That was fantastic, Cathy. I remember that you always remember that you speak so quickly, but it's good because you get in a sort of like double the amount of a normal paper in the time you would normally allocate. So managed to cover a lot of ground there, which is excellent because there is so much to say and so much to learn from the Australian experience. I think when you look at it from Scotland, there are obviously a lot of differences, just even in terms of what the land is like and what the buildings are like and the sort of arrangements that people live in. And also our underlying property law is quite different. But on the other hand, there are so many of the same challenges that we're facing in terms of how to get people to pay for buildings and, how to cope with tenants' rights. What rights should tenants have within buildings? How do you protect minorities, maybe more vulnerable people that are living within the buildings? That question of voting to demolish or terminate a building scheme is something that we don't have clear answers for really at the moment either. So this has all been super interesting. Anyway, I don't want to hog the conversation. If people want to ask a question at this stage, maybe you could use the raise your hand function, or if no one else is speaking, feel free to just unmute yourself and dive in. Ailsa, please unmute and put your camera on if you want.
Hello, thank you very much, Cathy. I'm Ailsa. I work for Built Environment Firm Scotland. We deal primarily with policy. So my apologies if any question is sort of going off on the wrong tangent. Obviously, a lot of what we've been thinking about within Scotland is to do with repairing and maintaining buildings and how to sort of sort those problems for the longer term. When it comes to repairing obligations and that kind of thing, are those all done through those schemes, or are there other laws that sit separate to that? Because obviously I'm aware that sort of there's all sorts of different schemes all over the world, whether they're run by cities, whether they're run on a state or a regional basis, as to how people have to understand the condition and the repair state of their buildings in terms of, be it building standards or public safety, that often comes into it. And I just wondered where that issue sat within what you'd been saying, just to get a little bit more understanding from my side.
Yeah, the answer is entirely privatised in Australia. So this is simply a private obligation, and that's something that I didn't really speak about. But this whole idea of putting responsibility on private citizens is a big problem in strata title, huge problem in the pandemic. So asking private citizens, you make a decision about whether people need to wear masks inside a building. That's just a decision that private citizens should never be expected to make. But governments love, once you get these privatised forms of ownership, governments love to default to them because it's a lot easier for them. So the answer is no, other than we have a building code, obviously, so the Building Code of Australia, but like most building codes, it's not retrospective. So you have to build in conformity with it, or if you do a substantial, refurbishment or something like that, you must build in conformity. But it's not. But if each time they update it, it doesn't mean you have to update buildings. We managed to get one update through. I did a lot of work with the Children's Hospital on children falling out of high-rise building windows, incredibly distressing stuff. And we managed to get the strata legislation changed so that every building had to retrospectively make their windows safe for children. And that was a really, really, fabulous change to the legislation. But as a general rule, it's the initial build that's regulated by the government, and let's face it, all over the world appallingly because of building defects, flammable cladding, all of that. We have that whole nightmare here. But once it's built, the obligation is simply private. And as I said, nobody checked.
Thank you. No, thank you. That really helps to clarify. Thank you very much.
Thanks, Ailsa. Sue Bride, do you want to come in and just the building defects, a subject close to your heart, perhaps?
Hi, Cathy. Lovely to see you. Thank you for your talk. It's really following on from the last question. And I ought to know the answer, but I don't. Do you have any compulsory reserve fund, sinking fund approach? Because obviously one of the issues is that you can, someone's buying or has already got a tenement, like in Scotland, where they're thinking of, making it compulsory for existing buildings, and you can sort of budget on the day-to-day the expected annual, maintenance costs, but the roof collapses. Cladding, obviously unexpected issue. So we have all these unexpected expenditures where suddenly the bills that people get sent are just unaffordable. And one way of trying to anticipate that, well, it wouldn't anticipate the completely unexpected, but you can expect long-term renewal, which you have to budget for. So I know under some systems there's you've got to have you budget for the immediate year, but you also have to have a budget for a 5-term plan and perhaps a 20-year maintenance plan. So you have to anticipate that there's going to be some quite expensive things coming down the line, so you can build up reserves for that. None of that covers the completely unexpected left field things like we've had with the cladding issue. But how do you deal with that in Australia?
There's compulsory insurance, so that's one thing that's written into the legislation. You have to have insurance, so schemes will have that if they have a flood or something like that. But in terms of reserves, no, we do in New South Wales have a requirement that you have a 10-year plan, but again, nobody checks. So we did, that was in the last round of legislation that was introduced. So you actually do have to have a 10-year projected plan for the cost of the building, but do schemes actually have it? Do they have the money? So again, that we've thought about it, but whether schemes do or not is another matter. One thing I will actually say about reserve funds, and this is an issue, and I do notice that Scotland has flagged this, the bigger your reserve fund, the bigger potential target you are for fraud, because that's something that's been a problem in the United States. I've seen some really good papers at conferences there about fraud in community associations. The more money you have in there, the more tempting it is for someone to do something improper with it. Australia also does have, you've probably, so there is you might have met Paul Morton of Lanark Finance in Australia, I don't know, at a conference at some point. Paul often comes to conferences. He runs a private strata finance company, and he actually lends to strata schemes. He doesn't take any security. You can't mortgage the common property in a strata scheme. I've spoken to Paul about this. He might be an interesting person for you to talk, for the Commission to talk to. He just says he knows schemes are good for it. They will pay him. He knows where they are. So this company, I have no commission for them. I'm not making a plug for them, but Paul's been around for many years. And so strata schemes can borrow to cover those costs. But look, the reality with strata schemes is if you've got a good committee that is on top of these things, they will do management well and they will do maintenance well. If you have a large number of disengaged owners, a large number of investor owners, often schemes will be very poorly managed and maintenance will not be done. And then, in a city like Sydney, obviously in those kind of beachside suburbs where people tend to be wealthy, have a lot of money, they can afford to pay for maintenance. There are a lot of very well maintained buildings. And then in the outer suburbs of Sydney, there are a lot of really badly maintained buildings that have a lot of investor owners who pay up. I mean, there's, a lot of residential property that's just very poorly maintained. Under our Residential Tenancies Act, there is a base standard that you must meet. So we have, it has to be obviously fit for human habitation. That doesn't stop buildings becoming incredibly run down. There's also then obviously the spectre of tortious liability if someone's injured through common property. And a lot of schemes do think about that. There's no doubt about it. They are aware of the fact that if someone falls because a balcony or a stair railing is rickety, they will be liable. And there are cases on that. And that does place some pressure on schemes to maintain them so that they're at least safe. But it's far from a perfect system.
Thanks.
Thanks, Cathy, and thanks for that question, Sue. Anthony, Beck, you've got your hand up if you want to unmute, join us.
Hi, thanks. This has been really, really interesting. My question is what do you see as the minimum powers that a body corporate should hold to be successful? I mean, clearly there's a need to raise and spend money for maintenance and improvement, but is there really a requirement to go into these kind of private legislatory powers because they seem to have a Pandora's box of unintended consequences?
Look, I think that's a fantastic question, and I must admit I was really excited to read the information that Frankie sent me, and I looked at the Commission's website. I think that's really interesting that what you are looking at is primarily maintenance, because what I always come back to in my research is the kind of rules that cause problems are the rules that are least related to stuff that is you obviously need to do. So the closer you stick to that things that are objectively necessary, and that is maintaining the building and making sure that it's okay, the less trouble you run into. The more you veer away from that, and the more you allow kind of creative stuff. Like, so often in Australia, we're talking about, you know, what's referred to as lifestyle development. So it's like living in a holiday resort. So you can imagine, if you picture America, there are a lot of them in America, and America loves this. You know, they love a bit of segregation, started with the Pilgrim Fathers and has gone on from them. Then they love this idea that they can create their own little mini communities. That's when you really start to run into trouble. So in terms of minimum powers, one thing that should be said in Australia, owners corporations, bodies corporate, don't have the power of natural persons. They only have the power given to them by the legislation. So it is limited. They're not, and that's not the case in the United States. In America, owners corporations have the power that is given to them by the lawyers that drafted the documents. So in Australia, it is tightly controlled because they exist via legislation and their powers are all the same. So America is much more a free-for-all, depending on the developer's lawyer. So the powers are limited, but the bylaw making power is way too broad. So you know, I don't know that you even need, like in Australia, a lot of bylaws are completely unnecessary. So yes, people make noise in apartments, but in the legislation itself, there is a section that says you may not make noise or disturb or cause nuisance when you're on common property or in your apartment that disturbs other people. So frankly, you don't need bylaws to deal with that kind of behaviour. It's covered by the legislation. I think in Australia's case, there's no doubt that Australians are neurotic about the idea of living in high density because we're not used to it. So when the legislation was originally created in the 60s, like I said, you know, dogs in an apartment, you can't have a dog in an apartment. You know, I know a lot of Europeans would think that was crazy that we were worried about that. So I think that some of the bylaw stuff in Australia has come from that idea that, oh, it's terribly odd to live in high density and we desperately need to control people. And the reality is you don't. So I'd say minimum powers, yes, are to do with things like maintenance, repair, that kind of stuff. Beyond that, goodness, I suspect you don't need more powers. And the more powers you give, the more problems that are created. I mean, it depends on also the kind of buildings you're talking about. If you're talking about really large-scale, complex, high-rise buildings, then maybe, yes, you are going to need professionals to help you. But you know, it should be very clear that you engage them in the same way that you engage a lawyer or a doctor or a gardener in your own garden, not that they actually run the building for you and they are the source of power. That's where real problems start to occur, I think.
So you front load at the setting up the body corporate rather than giving a range of free powers for the body corporate to act after the event.
Absolutely. And Australia initially, it was the case that there was lots of stuff that was in the. I'm sorry.
I have the same problem.
There was lots of stuff that was originally in bylaws that was alterable. So a whole lot of stuff about committees and meetings and voting and all the rest of it was originally in the bylaw section, which was alterable by either special majority or unanimous vote. That was in the original 1960s legislation. When it was reenacted in 1973, they realised, actually, this is a really bad idea. And they took all of that stuff out of bylaws and they just put it in the body of the Act and said, you know what? Everyone has to do meetings the same way. Everyone has the same powers. But that tension between what communities can decide for themselves and what is set by the state is a real problem in Australia. And also it depends on your politics. Like our Liberal governments will default, which is our Conservative governments, will default to, individual communities should be able to decide things for themselves. But I always think of Australia as being halfway between America and the United Kingdom. So we're we do probably have more less government intervention, maybe, or less government provision, but we're not like America. We do, readily accept that the government should regulate certain things, set rules. I mean, I don't know. People often say Australians are very happy to follow rules, where maybe it's our penal origins. We're very good at being told what to do. We do accept that is an okay way to go about it. But I would say that default to let private citizens decide things can often be quite problematic.
Thank you.
Okay, I'd have the feeling this conversation, thank you, Anthony. I've got a feeling this conversation could go on for quite a long time, but I'm conscious that we've only got 2 minutes left of the meeting, and then I think Teams will kick us all out, so we probably better draw it to a close. What I should do before we go is advertise to everybody on the call that we're having one more seminar in this series, which is going to be a month from today on the 21st of October, which I think is a Friday. Oh, here's your cat coming to join the call again, Cathy. On the 21st of October, it's a longer session this time, 2.5 hours from 9 o'clock to 11:30 on the 21st of October. And we're going to have 4 European speakers describing to us the apartment law in their country and speaking to us specifically about the mechanisms that they use and that their owners' associations can use to try to enforce payment of costs for repairs and renovation works from owners who are not paying their share. So that will be the focus of that discussion. Registration for that should be open hopefully later today or sometime tomorrow. If you're on our mailing list, you'll get an email about that, or no doubt we'll tweet about it. So please look out for that. Other than that, what all it means to say is to thank everybody very much for joining us, and in particular to thank Cathy for giving us such a fantastic whistle-stop tour of the strata title regime in Australia. So thanks very much, everyone, and hopefully see you on the 21st of October.
Thank you.